Good morning and welcome everyone to the latest instalment of Cover Talk. My name is Claire O'Brien and I am an intellectual property lawyer at Mills and Reeve. I am joined by our guest speaker, Madeleine Brown. Good morning, Maddie.
Morning everyone.
Who, as many of you know, is the intellectual property practice leader at insurers CFC. Maddie has been practicing in this area for many years, and we are delighted that she has agreed to share her specialist knowledge and experience in the IP insurance industry with us today. Before we get started, and for those in the audience who are new to these sessions, our conversation lasts about 15 minutes, and there will be a little time for a Q&A session. So do feel free to post any questions in the Q&A box during the session. These will be picked up by my colleague and insurance lawyer, Harriet Strevens, to deal with at the end of the session if time allows. Otherwise, we will respond to you by email following the session if you have left your contact details. I should also mention that this session is being recorded and you will get a copy of the recording and the slide deck after the session has finished. So let's get started then. Maddie, thanks very much for joining us today. I've got a number of questions I'd like to ask you, and perhaps we can start with this one.
Yeah, of course.
You refer to this topic as bridging the gap. Please, can you explain what you mean by that?
Yeah, of course. So I say that because intellectual property is often referenced in other insurance policies, but the breadth of the cover can be limited, which people may be unaware of. So, for example, it will often not include coverage for patents or trade secrets. And furthermore, it can be limited by territorial exposure and not provide cover for example, the US. A key point also to highlight is that the coverage within those policies is more likely than not will only cover defence claims, so incoming claims to you, and won't provide any level of pursuit, so outgoing claims, also known as enforcement. And as a final point, the coverage can also sometimes be limited in how it responds to a claim. So, for example, it may not cover a claim that would arise through your contractual obligations, so your clients and your third parties, which might be key to your business.
Okay, so given what you've said then, do you think it is necessary for business to take out an insurance policy specifically for IP?
I think that's a really good question. And yes, of course, I do. However, what I think the key point is to first of all question the coverage that's already in existence in your current insurance policies and question whether or not it goes far enough in the event of an IP claim and whether or not it's actually doing what it needs to do. On the current slide that you'll see in front of you, I've highlighted a few areas where you might find a level of cover in existence. So, and directors and officers insurance, so also known as managers liability policy, errors and omissions insurance, and cyber insurance. So in conclusion, you can bridge the gap with a specific intellectual property policy and bespoke it to what it's needed. So you could just add on the patent and trade secret aspect, which would bridge the gap between in the other policies, or you could consider a full IP policy.
Okay, so there will be a number of policies available on the market covering different things, but I wondered whether you could tell me what CFC's policy covers.
Yeah, of course. So our policy, as you can see from the rainbow wheel in front of you, is broad in its coverage. The core cover is the infringement defence policy, which covers against IP infringement claims both directly and indirectly. So the contractual indemnifications cover is there included. The next three are part of what we call the early stage strategy defence covers. So invalidation, oppositions, and title disputes. We then move on to the two sections of pursuit. So the outgoing claims, the cover enables you to enforce your IP, also known as enforcement and abatement cover under other policies. And then further, we also cover breach of contract cover. We do that within the defence section, but also the pursuit section. So coverage that may arise in the need to in the event of contract issues with your customers and clients. And as a true cradle to grave policy, we also pick up a level of business interruption cover. This is some sublimited because we don't have forensic accountants poring over stuff, but it does provide a true end cover to a full claim.
Okay, so I'm just looking at all those wheels that you have taken us through there, and it looks like you offer quite a comprehensive suite of cover for issues that might arise in IP claims, whether it's the infringement, the pursuit, or the early stage invalidation, or entitlement disputes, and then, as you say, business interruption. So it looks like a pretty comprehensive suite of cover.
Yes, we feel we've got a true breadth of in the event of a claim, cover from beginning to end.
Right, okay. And I wonder, in that case, whether you could give us some examples of the type of cases that you have dealt with.
Yeah, of course. So I've decided to pull through two our key covers, the defence and the pursuit. So the first one is a defence cover. And this is a client that we had that built websites for their customers. In this claim, a third party contacted our client alleging contacted the customer of our client alleging patent infringement. The company, our marketing software company, had a contractual obligation to indemnify that customer. As part of the claim, it was negotiated with that third party, a license agreement was negotiated, and the legal costs and settlements that ended up being negotiated were 150,000, and that was paid by us at CFC.
Okay. And is this example, was it in the UK or was it in another jurisdiction?
No, it was in the UK.
Okay. And and had a claim actually been issued on this one, or was it pre-action?
So this was pre-action.
Okay. And so the settlement, someone just looking on the screen there that you arrived at was so that legal costs and agreed settlement, £150,000. £150,000. So presumably the claim was higher than that, and that's what you settled for.
Yes, it was. It originally started at 300,000. So a very good overall result for us and the client.
Okay, that's interesting.
Okay, and the second one that I wanted to bring up is pursuit, which actually you'll note the costs, which I think is an interesting point on this. But this is a product-driven company. So this was an e-cycling company. They discovered a competitor at a trade fair showcasing very similar technology to their own patented technology. After much due diligence on this and review, together with us, we contacted the third party, and through negotiation, the competitor actually ceased sales and paid compensation to the insured. In this event, we paid 25,000 in legal costs to resolve this issue.
Okay, and again, was this in the UK or outside the UK? Where was this claim?
This one was actually in the US.
Okay, and I'm just looking at the level of fees incurred then. So I assume it was pre-action and no claim had actually been issued at that stage. Is that right?
Yeah, correct. It was pre-action, and the expenditure actually relates to the negotiation costs. So that highlights how, we are involved right from the very beginning to help the client.
Right. Okay. So it looks like so if it settled pre-action without the claim being issued, given that it did so, it looks like it settled quite quickly. So do you think the fact that your client had insurance was a factor in the swift settlement of the claim?
Yes, I definitely do. I think this allowed the client to have a very strong position from the outset and not to have their funds questioned. So it allowed them a good position to start straight off.
Okay, that's really interesting. So stepping back a little bit then, away from the examples that you have given, but more generally. So does CFC impose specific conditions that need to be met before it will cover a claim, other than the correct process, obviously, for notifying a claim? And I'm thinking here of things like, does it require a counsel's opinion on the chances of success?
So CFC actually operate alongside the client's chosen law firm. We need to be notified as soon as possible in the event of a claim. In regards to the pursuit enforcement cover, we do require reasonable prospects of success to be met. And whilst we don't set a percentage on this, we would expect the responses to lead to a greater than 50% chance of success.
Okay, well, that makes sense. And so I'd like now, if I may, to move on to our quickfire myth-busting section. I'm going to throw out some commonly held beliefs, and I'll be interested in your response. Okay, So the first one, IP insurance is too expensive.
It certainly is not, and I'm really proud of this. Actually, no, it's not. Its IP insurance can actually start from as little as £1,000, if not under.
Okay, so I'm sure that's great for the smaller businesses, and obviously the premiums will depend on the size of the claim. I'm sure
Yeah,
that follows,
yeah,
but
yeah,
it's
you're
good to
correct.
know that the smaller companies aren't shut out from getting IP insurance.
Yeah, exactly that. No, premiums can start from there, but we do have clients much larger and much larger premiums, but it very varies.
Okay. Okay, second one. If a problem arises, it takes too long to secure insurance. The process is too complicated.
No, at CFC, actually, we can provide in terms based off just website and revenue alone because we utilize our own data and resources internally. And terms can then be provided and even bound within 24 to 48 hours.
Sounds very speedy.
We are speedy, yeah.
Okay. The next one. Are businesses too small to need IP insurance?
No, definitely not. The smaller companies are a much higher risk. They're regularly targeted by large corporates. Think of the true David and Goliath situation, and it's very costly to them. So it's actually the size that really needs the insurance.
Okay, so we know there have been a lot of developments and procedures in place in the courts to help SMEs
Yeah.
either bring or defend IP actions. Particularly, I'm thinking about the processes and procedures in the intellectual property enterprise court, where there are certain cost caps and damages caps. So that helps to facilitate the SME being able to bring and defend IP claims. But still, it's still a considerable amount of money for a small business. So it's good to know that the smaller companies are considered as well as the larger ones.
Yeah, exactly. They can offset it.
Okay, right. And the final myth then, we have our own lawyer that we know and trust. Well, it's not, hopefully not a myth that. Do we have to use your lawyer?
No, so I touched upon this a little earlier, but no, you can use your own law firm. We do have a panel of experts if you require any recommendations in all different various territories. But no, please feel free to use your own.
That's good. So there's some flexibility there. So clients can use their own lawyer or they can call upon yours. I wonder, can they use both? Can they use a mixture of both?
Yes, they can actually. We actually regularly have what we call monitoring counsel operating, and they work alongside the law firm. And this can be very useful if it's a claim arising in maybe a more difficult or trickier territory.
Okay, and just to follow up from that then, do you have your own, so that's lawyers in terms of solicitors and things like that, but do you have your own favoured counsel in terms of barristers, or is that something that the solicitors can influence, or the clients?
Again, the clients can also have control on that point. So no, we don't control anything on our side.
Okay, so there's a good level of flexibility there. That's good to know. Okay.
Yeah, I think that's really important.
Okay. Well, thanks for sharing that with us today. It's clearly a very interesting topic, and I'm sure there's more we can speak about on another occasion. But we have had some questions actually posted in advance of this session, and perhaps we can look at those now because I think it's useful. They are of general application, and I'm sure our audience will be interested in those. Then perhaps if we have time, I will hand over to my colleague and insurance lawyer Harriet for any more that have come in during the session. Is that okay?
Yeah, of course.
Okay. All right. So the question was around the effect of managing international litigation risk and the types of insurance that are available. It was divided into 3 parts, which is quite interesting. So, for example, in Germany, which, as you know, has a bifurcated procedures for patent proceedings, meaning that validity and infringement issues are decided separately. We hear both issues together in this country. And I was just wondering, do you have any experience of insuring such claims in Germany?
Yes, we do. We've dealt with a number of cases in Germany regarding infringement. And actually further, we have actually just broadened our cover, as I highlighted earlier, to include validation cover, but this only has just been launched.
Okay, so presumably that was launched in response to a demand for it. And,
exactly that.
and have you had good take up so far of that new cover?
100% take up so far. So it's definitely a very much needed and requested cover.
Okay. So the questioner moves now to China, where the questioner fears that there is still some bias against foreign patent owners engaged in litigation with a Chinese company. That's how the question was kind of framed. I've got some experience of litigation and in that jurisdiction, actually. And as a more general point, I would say that I know that China is very keen to attract foreign investment, and they have specifically put measures in place to protect foreign-owned IP through their foreign investment laws and regulations on technology importation and exportation. But I wondered whether you have any experience of insuring claims in China, and how was that?
Yeah, I mean, most of our companies do operate globally, and we have actually recently had a case in China. And whilst I would comment and say it is a much more difficult territory to navigate, but with the right lawyers on your side, it is very manageable. So yes, difficult, but I wouldn't agree that it's biased necessarily.
Okay, I think people's experiences differ, don't they, in that jurisdiction and generally. But I'm certainly mindful of high-profile cases in China. It wasn't a patent one that I'm thinking of. It was an unfair competition one, the one that Jaguar Land Rover bought in relation to a copy that was made of its Evoque vehicle, and that was against a local Chinese manufacturer, and that was a high-profile success. So that's just one example that springs to mind. That actually, it's while there may be a perception of bias, people's experience differs really in that jurisdiction. But it's good to know that you can get cover through your organisation in those jurisdictions. And the last limb to this question was about litigation in the US with its high discovery costs. Do you cover those?
Yes, we do. We cover legal costs and expenses, which includes damages and settlements in the US. We've been involved actually in a number of IP cases, not even just on the intellectual property book at CFC, but actually across different insurance lines at CFC, which have, as I highlighted earlier, the IP exposure. So we have a number of experts operating in the territory.
Okay. That's good to know. Well, thanks for that. And it's good to know about the international coverage too. I was just wondering whether I can call on my colleague Harriet to see whether there have been any other questions posted during the session, Harriet.
Yes, you may well indeed. We have a couple of questions, and if I may, Maddie,
of course.
How do you see the IP insurance market developing in the future?
Yeah, I think it's already growing, and I think it's even going to further grow. It's as the importance of intangible assets are in turn growing. It's key actually that the insurance market reacts to this, and we meet the needs of the insureds.
And do you think that the development of artificial intelligence, for example, will give rise to more IP claims?
Yeah, I think that's a great question. The AI sector is quite embryonic at this stage, but as with any developing sector, it's more open. It's open to more litigation as clients position themselves in the market. We are actually already operating in this space, and know from our tech team at CFC that 90% of their claims are actually IP related, and therefore more likely than not that this sector, it will be the same. I think it'll be interesting to see how the IP claims will be categorized and navigated in this space going forward. And I think that's still something we're watching and observing.
It's a fascinating topic, isn't it? And very much in the news at the moment. Well, I'd like to continue as we do have more, but in keeping with our usual attempt to finish on time, I'm going to pass the baton back to Claire in order to wrap up. Thank you, Claire.
Okay, thanks, Harriet. So if we, I hear that we've had more questions. So if we haven't answered your question, we will contact you separately if you have left your details. Otherwise, a brief reminder that our next session will take place on Thursday, the 18th of May, when Andrew Tobin from Mills and Reeve will be joined by our guest speakers from our best friend firm in the States, Robinson Cole. And on that occasion, they will be looking at the US and UK insurance comparison. So do join us for that, because it sounds good. So we would love you to please complete the feedback form, which will appear on your screen at the end of this session, and do let us know what interests you, as this helps us to tailor our future sessions. And so all that remains now for me to do is to thank Maddie very much for sharing her insights on the insurance market, and to Harriet too for fielding the questions, and to you all for joining us. We hope to see you next time. Thank you very much.
Thank you so much. Thank you.